If you ask any of these people, any of our clients, what they want is no more funerals. They don't want anybody to have to bury one of their loved ones because of a terrorist attack that was perpetrated in part because of these sites.
People, if you shut them down, people will try to come back. It is easy to create a Facebook account, a Twitter account, a YouTube account. That's by design. And we want people to use these services, and we don't want to put a whole lot of barriers in their way.
Social media is the #1 tool used by terrorists to recruit new members and plan new attacks. When not bogged down investigating the president's ties to Russia, now former FBI Director James Comey made this point as frequently as he could. Listen to this chilling soundbite, Derek. Comey is describing the way ISIS uses Twitter to cajole impressionable young people to join the caliphate abroad, or if they can't do that, to commit terrorism on American soil.
They're pushing this through Twitter. So it's no longer the case that someone who's troubled needs to go find this propaganda and this motivation. It buzzes in their pocket. So there is a device, almost a devil on their shoulder all day long saying, kill, 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 kill.
So with the government so clearly identifying a link between social media and terrorist acts in the United States, it was just a matter of time until the lawyers got involved, because wherever there's a problem, lawyers are on the case, right?
That's right, circling the waters.
New federal lawsuits brought by victims of terrorist attacks in San Bernardino, Orlando, Paris, and Dallas, all brought in the United States, argue that because terrorists are communicating through social media to perpetrate attacks, they could and should be held liable if they don't take appropriate steps to stop it. We're going to speak with the lawyer accusing Twitter, Google, and Facebook of knowingly and recklessly aiding ISIS to recruit new victims and perpetrate attacks on American soil. And from the defenders of social media as well, Derek has a lot of information on that. I'm Jason Beckerman.
And I'm Derek Kaufman.
And this is Behind the Bar.
So, Jason, we got Keith Altman on the line. He's from the Excolo law firm, and he's actually taking on 3 giants of Silicon Valley. He's taking on the big 3, Twitter, Facebook, and Google. And he's going after them about the San Bernardino attacks. He's got 3 clients who were victims of the San Bernardino attack. We remember this attack from back in December 2015. 2 terrorists killed 14 people, injured 22 others. And now Keith has an interesting lawsuit. He's actually accusing the social media platforms that maybe inspired the perpetrators of these attacks. And he's saying, you're responsible for these deaths, and I'm bringing you to court to prove it.
So, Keith Altman, what are Twitter, Google, Facebook, and others not doing which you think they should be doing to eliminate or mitigating a terrorist threat?
Well, one thing is certain. There's no way they will sit and watch every single posting made to these sites, and that's not something that we really expect these people to do. What we do expect them to do is act reasonably, which means there are things that can be done to try to detect conduct that is suggestive of nefarious intent. For example, they are well aware that terrorists are using their sites. They know this. Number 2, they are well aware that the terrorists, even when they take them down, they pop right back up. But when they pop back up, there are things that they do to reconnect to their networks, which, if they could not do those things when you take them down, you keep them down. For example, a terrorist they take him down, he comes back up the next day, he changes his name a little bit, and then he sends out a whole bunch of friend and following requests to the people that he was connected to before they took him down, and that's how he rebuilt his network. That's not normal activity.
All these companies have millions, in the case of Facebook, billions of users. Are you asserting that there are sort of just common prophylactic measures they could in place to root these things out and to red flag them?
Absolutely. You know, as I said, for example, you take somebody down, drift from 146. We talk about this guy in our complaints, the 146th version of his account. They took him down. The next day he was back up as drift on 147. Seems to me it doesn't take a lot of technical skill in order to be able to detect that kind of behavior.
So, yeah, Keith admits they can't be everywhere, but he wants these platforms, Facebook, Google, and Twitter, he wants them to do more to frustrate and obstruct the avenues of communication that these terrorists are using. Facebook says this is asking way too much. We have robust terms of service. We've got a million complaints a day. It's a huge manpower requirement just to field those. Matter of fact, here's how Facebook's head of global policy management, Monica Bickert, puts it.
It is true that people, not just in the support of terrorism space, but in other policy violations as well, people, if you shut them down, people will try to come back. It is easy to create a Facebook account, a Twitter account, a YouTube account. That's by design. And we want people to use these services, and we don't want to put a whole lot of barriers in their way. That also means you get the bad with the good. When you take somebody down for having a troll account or a spam account, you have to expect they're going to try to come back. We do have measures in place to try to prevent that. It doesn't mean it's perfect.
So yeah, Jason, this makes sense. It's an enormous undertaking of manpower to have the people to assess all of these because they don't want to chill free speech. They want people to be able to get profiles. That's part of Facebook's business business plan is to make it very easy to start a profile. They don't want to cut down the ease.
But just to push back on this, on the difficulty, we heard James Comey speaking at the top of the podcast and talking about the persistence with which these terrorists act in continually haranguing potentially cajolable individuals into committing terrorist acts of terror. And it seems that at some point through this persistent cajoling that the Facebooks and Twitters, if they put in the proper mechanisms in place, and frankly, to Keith Altman's point, we do have these profiles created about ourselves. They know a lot about what we do online. It seems that at some point the technological know-how is there to really clamp down on the most serious and aggressive forms of terrorist recruitment.
So let's assume for a second that there's some low-hanging fruit that Facebook, Twitter, and Google can do to further combat terrorism. There's some measures that they haven't yet taken. Even if you have that, the plaintiffs have a huge hurdle here, Jason, right? I mean, they have to prove a causal link between the social media sites and these actual terrorist acts. They can't just say these were inspired by things they saw on social media. There has to actually be a real link there. Keith acknowledges this point, but he thinks he can overcome it.
It's a little hard to say absolute but for causation. But for liability to attach under the Anti-Terrorism Act, you don't have to show a direct but-for causation relationship. Under the Anti-Terrorism Act, you don't have to show that Facebook directly perpetrated or was involved in the Orlando attack, for example. The way the Anti-Terrorism Act works says that if an American is harmed by an act of international terrorism, then companies that provide support to that terrorist organization can be found liable. ISIS was involved in this attack by radicalizing Mateen, for example, in Orlando. Therefore, Facebook, Google, and Twitter can be responsible for that attack.
I think what Keith is doing here is in some sense a noble cause. I think he's got a huge legal problem with bringing this, and he alluded to it. We tried to get him to talk more about it, but causation. He is bringing a tort action, right? I mean, he is saying you have violated some duty that you have, and we think that it resulted in these San Bernardino attacks or the Pulse nightclub attacks or what have you. And he's also got to prove that link. He said causation is not necessarily required under this, but it's a fundamental requirement of any tort action. You've got to prove a duty, you got to prove violation of that duty, you got to prove that it had a causal relationship, a proximate causal relationship. And that's where I really think he's going to fail.
So just to smooth the edges on that, I think you're absolutely right. So basically, he's got to show that if it wasn't for the acts of these social media organizations, the terrorist attacks wouldn't have happened. He's got to show that at some level, right? He's got to point to some causal link. And I think it's impossible to do here. You take Omar Mateen, the guy who did the shooting, the awful shooting down in Orlando. He was motivated largely based on what I've seen in the media, based on his repressed feelings of homosexuality that had him lashing out, not just in this instance, but for years beforehand against gay people, where he would then admit to his wife, I believe, that he had these homosexual leanings and it made him angry. He was also influenced by domestic terrorist acts, and he said by the actions of the U.S. government overseas, what he felt was unjust actions there. That's very, very different than what the Paris terrorists had in mind, which is more of a territorial grab, keep you out of Middle Eastern soil and allow our religions to flourish. That's very different motivations. For you to say that notwithstanding these different motivations, that Facebook or Twitter or Google are responsible for both seems to be a but-for causation stretch. It really does.
I agree. And a lot of people we've seen in these attacks have been described as lone wolves, right?
Yeah.
These are people who may be influenced in some way, but they're making a volitional act to go out and perpetrate these offenses. Now, if he has some sort of smoking gun where they used Facebook or Twitter or Instagram as a platform to raise money, to then procure the weapons that they then carry these things out, that's an entirely different case.
That is a different case.
Now you've got someone who has directly benefited from those platforms to perpetrate the crime. I think you can get causation.
But that doesn't necessarily seem to be the link that they're drawing in these lawsuits, that this kind of but-for causation happened. I really agree with what you're saying, that just it seems like an attenuated link.
So really, Jason, the last legal battleground where this is waged is the Communications Decency Act, which says that websites aren't responsible for what their users put on their platform as long as they're not the ones actually saying it. And this is exactly what's in the mind of Monica Bickert, who again is Facebook's head of global policy management, whenever she addresses this topic publicly. Here, take a listen.
Facebook is not the speaker. We are the place. We're the space for people to come and talk. But what we want to do is make sure that people know how to use that space and how they can best engage.
But Keith said it's not so simple.
It's our position that when they interact with that content, by putting an ad together with a posting, they're sending a message to me, the viewer. They're telling me, you're going to be interested in this ad because we know about you and because of what you're looking at. And that is a very big difference here than what has been argued in the past in other cases.
Do you think that litigation is the appropriate mechanism to get these changes in place? Because the problem I have with what Keith is doing is they say they have a lot of voluntary sort of thinking about this issue where they can be really open about how we address this, and they bring in all sorts of experts on the subject. In litigation, everyone's going to tighten up, and I'm not sure he's going to be able to ultimately push forth the change that he wants through this mechanism.
Well,
I don't think litigation solves everything. Litigation's useful
litigation does,
things.
but there's only really two ways to go about it. One is litigation, right, and the other is legislative change, right, getting Congress to act. But when you're individuals who are being harmed by terrorist attacks, and you're going up against the Facebooks and Twitters and Googles of the world, which are the largest companies in the world, Facebook and Google, two of the very largest companies in the world, right? Who have huge lobbying arms throughout not only California, obviously, but throughout the country. They're enormous donors to political campaigns. They have a lot of political sway. I think the idea Dianne Feinstein did a few years ago, proposed some legislative changes. Two things. Number one, they didn't go anywhere. And number two, they were even sort of milquetoast in what they were. They weren't going to make profound change. And, I don't know, maybe litigation is a long shot, but I think if you look back to sort of the way, to perfect example, we talked a couple weeks ago about Ralph Nader, right? Mm-hmm. He was the champion of litigation against the Detroit car companies, and the reason was those companies held a lot of sway over politicians, and they couldn't get safety laws passed. So how did Ralph Nader go about it? He said, you know what, I'm not going to go to the legislature anymore because I can't get anywhere. I'm going to go to the courts and try and make change. It's a long process. The odds are it's an uphill climb, but if you get there, you can make some profound changes.
Let me ask you a question. So one of the points that I think is one of his stronger points is this idea that Facebook has this information at its disposal and is using it for a profit motive. They're running advertisements against ISIS-inspired videos, and if you go flip through his lawsuit, it's pretty jarring to see the ISIS flag as sort of screen grabs next to an advertisement for mattresses or something like that.
Yeah.
Usually they're innocuous, they're not necessarily related, but they are using information to get that to the eyeballs that they want to really generate a huge profit. Facebook is a multi-billion-dollar company. What do you make of that? Is that a problem that's so intractable, or could they shut that down and not have certain content have advertisements? I know it's algorithms, but
I think this advertising issue is really a red herring. I mean, if Facebook has the ability to say what is a terrorist recruitment video, and by the way, if they knew about it, they would take those down. And I take Facebook and others at their word that if they knew there were terrorist recruitment videos up, they would take those down as soon as they learned about them.
Sure, it's bad for business for them too.
The idea that because there's an ad running next to it, it somehow means that they're more aware than they're saying about the content of the video. I just don't buy it. We know, right? Ads are just sort of put up there. You have these third-party vendors who put up ads. It's not the same people that are creating the content that are putting up the ad. It's not the same people that are hosting the content that are putting up the ad. You're linking out to all these various ad delivery services. It's incredibly complex, far beyond my understanding of the way the web works. But it's an incredibly complex spiderweb of different websites populating these fields. I just don't see there's a link between them.
I tend to agree. Look, I mean, if there's somewhat of a rev share where the ISIS organization is getting money and then funneling it directly to the people who are perpetrating these attacks, maybe you can have sort of some hay to make, but he doesn't get there, and I think that's going to be very difficult to get. That the lone wolf in Orlando was getting money from the videos that he watched. I don't think he has that, and that's going to be a fundamental difficulty for me to see where there's any material support.
Right, Derek. Where does this lead? He said that it's a victory just to have brought the lawsuit, regardless of whether or not the courts decide to dismiss these lawsuits. There are 4 different lawsuits brought in 4 different jurisdictions. I think he has Michigan, California, Florida, and one other jurisdiction that he brought a lawsuit in. I'm sorry, there are 2 in California, 1 in Michigan, and 1 in Florida. Right. Where do these lawsuits go? Could any of them survive motions to dismiss?
I don't think so. I honestly don't see it. I think he's got laudable goals, but even his goal is an impossible one where he wants no more funerals. I mean, terrorism existed long before these platforms existed. It will exist long after. So I think he wanted to raise awareness, but I don't see him getting over that fundamental hurdle in a motion to dismiss of causation. I just don't see it.
Yeah, and even if it does get beyond a motion to dismiss, I think it'll be because there are judges judges, lone judges all over the place who do crazy things. I think once you get up to the next level, or the appellate level, or whatever it is, you're going to have a very difficult time. Remember, these are acts. These are multinational companies dealing with issues involving terrorism and laws that restrict certain acts that relate or support terrorism. You have big-time federal stakes here. It's not just going to be your local federal judge who's deciding this issue. It's going to go up to courts of appeal who are really going to want to make law on this issue. And from everything that I know about the way that things work and the law in this area, it seems unlikely to me that a federal appellate panel would uphold these lawsuits.
I'd have to agree.
Parker, we got some mail time?
We do have some mail time. Remember to write your questions and comments to behindthebar@tmz.com. First one up is from Dimitri. After a judge dismissed Aaron Hernandez's murder conviction, the DA said they would take steps to appeal the decision. If the reasoning for dismissal was a written law, how will the DA go about appealing the dismissal?
I think it's a great question. I mean, this is an appealable issue. It's a final decision. They're going to be able to challenge it. And I think the argument that's most persuasive to me is this is a doctrine. This is not a law in the sense that it's a statute that was passed. This is an equitable doctrine that goes back many centuries about our justice system. And the argument that is persuasive to me, I'm curious what Jason thinks, is Aaron Hernandez didn't die of a heart attack. Ken Lay died of a heart attack. His conviction was wiped out, and all those Enron victims weren't able to get their restitution. He had no choice in the matter. Aaron Hernandez, we've now seen his suicide note, may have been aware, but even if not, he chose to truncate and end his appeal by killing himself. He knew that he couldn't carry on the appeal in death. So shouldn't that matter if you make the decision to end your life rather than your life just ending?
You know, I know from having talked to people in the newsroom and then in the outside world after we did a podcast on this very issue a couple of weeks ago that the opinion that I have is very unpopular and it doesn't make a lot of intuitive sense. But my answer is no, it shouldn't matter. You know, our entire system of justice, and you and I both believe very strongly that our system of justice, although flawed, is the best system of justice that exists in the world. And that system of justice says you apply the law regardless of the specific circumstances of a case. And that's important because if you give judges a lot of discretion as to when to apply a law and when not to apply a law, you get a corrupt judiciary. And that's what we got away from when we created our system of justice. We got away from the British system that had corruption galore and the French system that still has corruption galore, if you believe what you read, and I do. But our system has less corruption. Not to say there isn't any, but it certainly exists. And the way that you get away from corruption is to bind judges to the letter of the law, not just the law that's written by legislatures, but the precedent that has come before it based on judicial decisions in the past. And if don't get away from that because you are upset about one case, about the outcome of one case, because this is totally unfair, and I get it, and it's awful, and I get it, and it hurts, and I get it, and all that stuff. But it doesn't change the fact that's the law, and this is how we apply it.
Look, there's an adage that says high-profile cases make bad law.
That's
and there's a reason for that. When judges have the spotlight on them and they hear this outcry of people that are just upset over Aaron Hernandez possibly benefiting from his own suicide, I think the tendency is to lean in that direction. But we really have judges who aren't supposed to be subject to those pressures. That's why sometimes they have life tenure. They have some more protection from the electoral process because we want them to think with a clear mind about what's right to do and what is compelled by the letter of the law.
All right, next up is from Katie. I have a question over the pretrial motions if Chris Soules' case goes to trial. If you were the defense lawyer, would you request a change in venue for the trial? As you know, Arlington is a very small, and potential jurors from the surrounding area are very familiar with Chris and now know the details of his alleged crime. How easy will it be to seat an impartial jury, seeing as most jurors not only know Chris, but also probably know the victim as well?
Well, it's a good question. I don't think Derek or I know enough about Arlington, Iowa to make this determination, but yes, it does seem that there's a risk of a prejudiced jury. It's not enough that they know who the defendant is. They have to have formed some sort of preconceived notions about the facts of the case. But in a town of this size, a county of this size, it would seem difficult that he will get a neutral jury of his peers. I would not be surprised if it's transferred for venue purposes to a different county.
I think that's right, but where do you go? At some point you need to we have national stars at this stage. He's on The Bachelor. Where's he going to go that's any better than the county he's necessarily in? I mean, OJ was as big of a case as you could possibly get, and that was ultimately they impaneled a jury. It was a very difficult process, and there were, I believe, attempts to change the venue to find a more impartial jury, but that was as high profile as you can get. Eventually you got to seat people and trust their answers on the questionnaire and get the job done.
I knew OJ. OJ was a friend of mine. Chris Soules.
You're no OJ.
You're no OJ.
All right, and that is it for Mail Time.
Thanks very much for joining, everybody. Join us again next week.
Yeah, keep writing in those questions, review the podcast, and check it out. We'll be back next week.
You want to do a shout-out to your Twitter and Facebook page? We haven't, or an Instagram page? We haven't done that in a while.
Yeah, my Instagram is Delfunker, and my Twitter...
Oh, goodness gracious.
Do you remember yours?
Good God. All right, thanks very much, everybody. We'll see you next week.
Thanks, guys.
Thanks for watching. If you want more nerdy deep dives into the legal side of celebrity news, hit our subscribe button right here.
And check out our previous episode over here.